Anyway, it's my pleasure to introduce the first two speakers. It's Jimmy McLaughlan from the Methodist Mission. He's a business development leader there, and Kayla Stewart, who's a researcher at the University of Otago Research Legal Issues Centre. Now, Kayla's got a background in both sociology and law and enjoys researching at the intersection of those two topics, and the topic she's going to address us on, information sharing and high needs clients, or that they're both addressing us on, is at that intersection. So I'll hand over to Jimmy. I think you need to put... Thanks. Get you wired up.
Okay. Oh, thank you. Tēnā koutou katoa. Thank you all for, thank you first to the OPC team for obviously making this research possible, and obviously the opportunity to speak today is really a valuable one for us. I'll just start, as Nicole said, I'm Jimmy from the Methodist Mission. We're based in Dunedin. My role is business development leader, which is really a role around fundraising, new program development, and then sort of looking at this our sector in terms of social services to work out what kind of strategic needs are around and how we can connect up with important issues. And obviously privacy is a really big area there for us, which I'll talk about briefly. So I'll introduce a little bit of information about what the Methodist Mission is and does, and then I'll throw over to Kayla, who was our research, our sort of lead researcher on the project, who will walk through the actual methodology and some of our key findings from the project. So really happy for some questions at the end, and then afterwards as well. So I'll just point out before I start that all of these resources are available online through our website. So there's plenty of ways to get hold of them. But if anyone wants to see a copy or help us distribute something, that'd be great. So just let us know at some point. So if I can get the clicker working, right? So. As I mentioned, we're the Methodist Mission based in Dunedin, so obviously not your sort of typical privacy research institution, but we are very interested in a lot of social sector research and a lot of research around the issues that impact our clients and our practitioners. So we're a multidisciplinary social services agency, so we deliver early childhood education, we deliver social work, we deliver foundation education for youth and adults, we work in prisons, we do community development projects, we sort of cover a high needs niche in terms of service delivery. So one example might be, we might have our Polytech in Otago delivers foundation education. We will deliver the similar courses to students who maybe are homeless, have acute needs around mental health or addiction, and maybe have some behavioural or sort of social dysfunction going on. So we do sort of specialise at working at the kind of the hardest end, if you like. Our focus for all of our program delivery is building skills and resiliency. So we're not necessarily an emergency or crisis provider. We basically are looking at delivering change in the people that we work with. So there's just a brief rundown of some of the services that we deliver. So we're fairly varied. We deliver throughout Otago and Southland. So why privacy research for us? Well, I guess the important point to emphasise, and probably everybody already knows this, is that it's actually a really critical part of delivering social services well. So for us, we've got two sort of really important needs that obviously kind of meet in the middle where there's tension. And one is, it's essential for us that we respect and recognise privacy of the information that our clients provide for us. Obviously that in itself is important, but it's also an important part of maintaining an effective relationship in terms of service delivery. So that level of trust and respect is really important in terms of doing our core work. So that's an important privacy point. The other part obviously is information sharing. So we try to work in a connected, collaborative way with other agencies, and one of the key requirements for that is actually sharing information about the people you're working with, which obviously has at times become, the failure to do that sometimes can be catastrophic, and we see some high-profile cases around domestic violence or abuse where that hasn't happened. So that's sort of the context, I guess, that we're interested in examining privacy a little more. the evidence that we had before we started this was that practitioners, and I'm generalising here, but practitioners are interested in getting it right, but often lack the confidence or the resources or the knowledge to actually apply those principles in practice where you get those difficult issues. So while a lot of practitioners will all of them will acknowledge privacy is important and information sharing is something to aspire to, the actual application of that was difficult. And we see that in our own staff and with staff that we regularly collaborate with. So when the opportunity came up to look into this through the Privacy Good Research Fund, we were quite excited because the opportunity for us was to basically examine those issues, dig around a little deeper, and then look at, okay, what have we learnt and what can we do in terms of creating a practical set of resources, because that's our emphasis. We obviously want to conduct really good quality research, but we also want to make something at the end of it that's practical and functional. So Kayla will go through this now, but we've produced a set of resources that are being used by a number of practitioners already. We've got a couple of government agencies who are looking to use our resources in their own internal staff training, and we're going to keep working on this area. There's still some more work needed because we think if we can make that connection between the Privacy Act and some of those overarching principles and then what we do in terms of service delivery, ultimately that's going to mean good things for our clients, and that's essentially what we're all about. So. The quick example, just to give you a little bit of context before Kayla ploughs in, is obviously this is a fictional person, but we've got a person here, Sarah, who has a gambling addiction, which is obviously having serious knock-on effects through her family, and it's having a detrimental impact. This is commonly how these issues will be surfaced. It might be someone at a school who notices strange behaviour and starts asking some questions, what's going on. So social workers in schools is this example. So we've got a social worker here who's gone, I've noticed some strange behaviour in the children, what's going on? I've dug a little deeper, and it's obvious now that there's some bigger issues here and requires a multi-agency approach to help this family get through some of these problems. So when that happens, when you've got a situation where maybe you've got referrals made to addiction services, budget services, a social worker, maybe you've got some criminal justice involvement, obviously it's beneficial for those multiple parties to be able to share information about that client. And so this is, if you can sort of keep this example in your heads, if you like, this is the situation we're talking about. You've got a social worker who gets this at 4 o'clock in the afternoon. Or what am I allowed to share? What do I have to protect? What do I disclose? How have I disclosed it? All of those questions are really where the rubber meets the road in terms of privacy and high needs clients. So I'll throw over to Kayla, and I guess this is just a little bit of information about where the sector is. Social investment approach is government's priority at the moment in terms of social services. Obviously, data is a really big part of that, and sharing data, gathering data, and then sharing data. So there's a number of issues there around information sharing that we're keen to look more into. Obviously, what we're primarily looking at here is information sharing between agencies or practitioners, but there's other issues to look at here around information sharing to funders, to researchers. So it's all part of that bigger picture. So I'll throw it over to Kayla.
Cool, tēnā koutou katoa. So just picking up where Jimmy left off, a quick overview of the Act, which I'm hoping because you're all here you're pretty familiar with. But so the Privacy Act is the primary legislation that controls the protection and disclosure of information. And there's the 12 privacy principles which concern the way information is collected, stored, disclosed, and so on. So in 2013, a new sharing framework was introduced entitled Approved Information Sharing Agreements, which aim to really facilitate information sharing between approved parties to those agreements. So currently there are 3 in operation, one between the IRD and the Department of Internal Affairs, one between the IRD and police, and finally the agreement for improving public services to children. So our research was funded by the Office of the Privacy Commissioner, and it examined both practitioner and organisational competency across a range of agencies, specifically agencies who are engaged with clients who have high and often complex needs. And there was a really focus on the sharing principles, so Principle 11, limits on disclosure of personal information, and Part 9A, the information sharing agreements, which I've just mentioned. So we conducted this research using a triangulated mixed method approach, whereby we had surveys and interviews and we conducted these concurrently. So it was really important for us to be able to capture the different perspectives of agencies and then the people on the front line who are actually working with the clients, and sort of establish whether there is a disconnect between organisational expectation and what people are actually doing in practice when they're working with clients. So our survey, we circulated this to various agencies in the social services sector, health sector, the education sector, justice and legal, and other government organisations. And the way we circulated this was through mission networks and having some of our contacts distribute to their databases, as well as advertising in various online social service newsletters. So we really aim to reach a broad audience of people working with these clients. Essentially, we wanted to measure competency, which is difficult to measure in a survey form, because obviously we don't want to go out and test people. So what we tried to do was ask at an organisation level about policies in place that agencies are using, and then practitioner we tried to measure using asking how confident they were using the principles, had they received training, and that sort of thing. One problem, a small limitation, of course, is when you're approaching people for research into the Privacy Act. It can be a common thing where people say, oh, it's the Privacy Act, I don't know anything about that, I'm not going to participate. And so there's the kind of people that you miss, and that sort of came through in the interviews. So a couple of the participants said, I'm not sure if I'm going to be much help to you, I don't know anything about the Privacy Act. So there is the potential that we miss sort of capturing those people. So interviews, again, targeted practitioners and managers from the same sectors as the surveys, and ended up conducting 10 interviews with managers and 10 interviews with practitioners. This gave a rich understanding of the issues, and we recruited these participants through invitation and also through snowball sampling. So now if we just share some of the results and findings. So majority of organisation received requests for client information. Most of these are from clients themselves and government agencies, so not so much from other agencies such as those in the social service sector. Most practitioners have shared information with another organisation within the last year, and more than a third did so 21 or more times. So a lot of sharing is evidently going on. So training, nearly a third of practitioners report not being trained in the Act and the principles, and of those trained, some considered this training to be inadequate, and not all organisations are training staff on whether other legislation or formal memorandums of understanding are trumping the Act. Some interviewees were quite frank about what they saw as inadequate training or no training at all, and I'll just read a quote from one practitioner that sort of sums this up. But it would be an easy trap to fall into for people to make mistakes because the training we get isn't very good. So some managers also found training staff to be difficult as they found the legal side of things hard to understand. A couple mentioned reaching out to the University of Otago law faculty if anyone could come and do some training or help them develop their policies. So that may be sort of an access issue there. So applying the principles. Very few practitioners found the principles easy to apply, and there was a mistaken belief by some practitioners and managers that they are complying with the Act by withholding a client's name, even though they're still providing identifiable details. So I'll quickly share one story that a manager shared with me. So he talked about having a client that they were very concerned with, and they knew that they were working with another agency, and he called this other agency. So he said, I described this story and I said, I think you might need to know da-da-da-da-da. And we had a 45-minute chat because they were concerned about what they were hearing. And when I put the phone down, neither of us had said the person's name, address, or age. So I should add, this was despite the fact that that manager had actually gone to the client and the client had explicitly not consented for that information to be shared. Then the agency who received this information then went on to contact the client about it and discuss these issues. So clearly the person was still identifiable from the information shared, despite that sort of this go-to mentality that privacy means not sharing a name or age, address, that sort of thing. So privacy officers. So the Privacy Act requires that every organisation has a privacy officer, and concerningly just over half did in our survey. Most practitioners do not know who the privacy officer at their organisation is. And of course, as well as dealing with information requests, the privacy officer is required to ensure and encourage compliance with the Act. And so if there isn't a privacy officer or staff don't know who this is, it's hard to see how compliance with the Act can sort of be ensured. So consent. This was a really big theme that was identified in the interviews and also touched on in the survey. So over a third of practitioners surveyed believe information should only be shared with the informed consent of the client, even if it's allowed by the Act. And this was really put down to helping build and maintain a trusting and transparent relationship with the client. So a lot of the participants talked about how this can actually be used as a way to form that client-practitioner relationship and sort of establish that trust and transparency. So obtaining information. So nearly half of practitioners have experienced a lack of response when requesting client information from other organisations. Nearly 3/4 have a formal system for managing information requests, but less than half have a system to ensure that a response to an information request is made in the required time frame. And less than half of organisations that participated said they're actually meeting the time frame that's required. And then on the other hand, we have managing requests, and again, there aren't the systems in place regarding timeframes. So it was good to see that nearly 3/4 of organisations do have a formal system for managing requests, but less than half have a system to ensure requests are responded to in the required timeframe, and less than half that participated said they're actually meeting the timeframe required. So disclosing information. So most organisations require staff to consult with someone before disclosing information. Of course, that sort of lends itself back to the issue before about if you don't have a privacy officer, then who are they doing this with? Under half of the practitioners reported being required to consult with another staff member about whether information can be disclosed. And the interview participants often said as well how they liked having someone else to consult with, as it took some of the responsibility off them. So there appears to be a disconnect and possible non-compliance there between managerial expectation and what practitioners are doing. So privacy in a Māori worldview, this was something that came up during the interviews, and there was a sentiment that information is collectively owned by the whānau, and so at times the Act is incongruous with this worldview, and the Act is often being breached because of this. And I spoke with several Māori providers, and this popped up a couple of times, and they said they were quite willing to blatantly disregard the Act to give effect to this. So some of the challenges that the participants said, so information being withheld when it was believed it would benefit the client, not knowing who to share information with. Some organisations and practitioners feared sharing information in case it places them in breach of the Act. And then sometimes practitioners really thought that the Act was being used as an excuse. So they may have the client's consent, they make contact with the other organisation, and it simply can't tell you because of the Privacy Act. So that was frustrating for practitioners. So we made some recommendations on the basis of our results, the first one being appropriate staff training. So some participants also spoke just along that lines about how they didn't like internet training, so some are being given training online, but they preferred face-to-face so they could actually discuss issues and run through some scenarios. Regular audits of IT security, all agencies having a privacy officer and staff being made aware of who the privacy officer is. So this can be as simple as having that printed out on a poster and put up around the organisation. So that's one of the resources that we produced. And promoting the benefits of having a privacy officer, of course, and the training available through the Office of the Privacy Commissioner. Education at an operational level, so agencies and practitioners know their obligations under the Act and incorporate them into their policies, and importantly their culture as well. And again, the resources on the Office of the Privacy Commissioner website. We think that the issues raised regarding a Māori worldview and privacy warrant further exploration, especially in light of the Treaty of Waitangi, and that all staff members working under approved information sharing agreements are comprehensively trained in their use. So I haven't had time to touch on that, but the results were fairly similar, with practitioners not being trained in its use, not feeling confident in identifying adverse actions, and similar. And then also agencies and practitioners utilising the guide and A to C of approved information sharing agreements produced by the Office of the Privacy Commissioner. So we thought this was a really, really good resource that they could be using. Also along that lines was investment into a more usable system to allow for and encourage information sharing under approved information sharing agreements. So whilst many people thought that they were a really good idea, in practice they were really hard to use because the systems just weren't there, and also resourcing and financing the systems was another issue. The inclusion of NGOs as parties to the agreements to be considered, because often if a person is involved with government agencies and they do have high and complex needs, they're also going to be in touch with people from social services or justice, things like that. So yeah, exploring that. And then short go-to guides on information sharing and certain privacy principles be produced. And these be written so that they're actually easy to understand and accessible. So practitioners don't have a lot of time to be reading big documents. They want something that they can go to then and there. So even possibly something like an app might be helpful as well. So in conclusion, both agencies and practitioners are conscious about the need to protect client information, and they do consider this important, and I really want to stress that because they did have this at the forefront of their mind. But there is some non-compliance, and often this was through simple ignorance, or occasionally it was blatant. Various challenges faced at both organisational and frontline levels. Some of these may be ameliorated by increased knowledge and training, along with implementation of new systems. So under the SIF review, there were some changes regarding the introduction of a new information sharing network. So that's those sort of changes at a macro level. Then we need meso organisational changes and micro levels. So that comes down to changing that culture and having practitioners skilled up. And again, this all comes back to striking the balance between protecting privacy and having all of the pieces of the puzzle so that everyone can provide that wraparound service for the client. Thank you.